If you are in a serious motor vehicle accident and you cannot work as a result of your injuries, paying your monthly expenses becomes a real problem. This can then also lead to bankruptcy. Having a personal injury claim outstanding at the same time you're in bankruptcy raises some intricate, difficult legal issues. In this video, I will give you a summary of where you are likely to stand with the bankruptcy and trustee. First of all, when you file for bankruptcy, all of your property vests in the bankruptcy trustee. If your personal injury claim is outstanding, that is property because there's value there that will eventually be realized. So that lawsuit actually vests in the trustee for the benefit of your creditors. Now, the practice has developed that the trustee will allow your personal injury lawyer to continue to pursue the lawsuit, and then upon settlement or judgment, the trustee will review to determine what must be paid to the trustee for the benefit of the creditors and what you as the victim can retain as your own property. Now, the general starting rule is that one of the main claims for general damages for pain and suffering, inconvenience, and loss of amenities of life, that is considered by the courts to be personal. And so that will not form part of your bankruptcy for distribution to your creditors. And so the general damages for pain and suffering, you can retain 100% for yourself. The next question is the loss of income claim. This has to be determined by dividing it between the past loss of income that you recovered up to the time of settlement or judgment and the future loss of income from the time of settlement or judgment far into the future. Now, if you settle the claim, let's say while you are still undischarged bankrupt, then what that means is the past loss of income that you recovered in your settlement will vest with the trustee. If it doesn't vest, and this is getting technical, it would still form part of the surplus income that would then be payable to your creditors. For example, there's a guideline that for a two-person family unit, any income over $2,576 per month as of the date of this video is considered surplus income. So in other words, you get to keep that $2,500 approximately, and the rest has to be paid for creditors. So back to the personal injury claim, the past loss of income that you recovered, if it's in excess of $2,500, part of that excess will be paid to the trustee. You can keep the $2,500. Now, for the future loss of income, what happens is when you get your discharge from bankruptcy, then that future income past that date of the discharge, that is not paid to the trustee for the benefit of the creditors. You can keep that. But any future loss of income up until the date of your discharge, whenever that happens in the future, again, any surplus over that $2,500 is paid to the trustee in bankruptcy for the benefit of your creditors. So the takeaway then is the long-term future income, if it's a serious injury and you can't work properly for the next 15 to 20 years, that future income after you've been discharged from bankruptcy, you will be able to keep for yourself. Finally, a third head of damages that is typically discussed in an issue is the loss of housekeeping claim. That's the amount that you recovered in your settlement for your inability to do your household chores, to take care of your children, and to run errands, to do shopping if you can't do that, etc. So that amount, again, the courts have typically held that is personal because that's from the personal injury claim, and that will not form part of the assets which have to be paid to the trustee in bankruptcy. So that just gives you a brief outline of three of the main heads of damages and how the bankruptcy will affect them. It's a complex area and it's often dealt with on a case-by-case basis, so you will definitely need top-notch legal advice from a personal injury point of view and your own counsel in the bankruptcy as well.